to talk to you a little bit today about what is a preliminary hearing, also called a preliminary inquiry, and when can you elect to have a preliminary inquiry. So I'm going to give you an example. Let's say you're charged with sexual assault on an adult, and the Crown's elected by indictment. So what happened on September 19th of this year, of 2019, Parliament brought this new law in that got rid of preliminary hearings for all offenses unless you're facing 14 or more years in jail. Now, a sexual assault charge carries a mandatory maximum of 10 years, so you're not allowed to have a preliminary hearing anymore on that particular case. So you can elect in the Ontario Court of Justice, or you can elect in the Superior Court of Justice, judge alone or judge and jury, but you're not allowed to have a preliminary hearing. And that was a very important right that they've taken away, by the way. So now it's restricted to cases where mandatory maximums of 14 years. So, for example, if you sexually assault a minor, someone under 16, the age of consent, by the way, is 16. In that case, it's a mandatory maximum of 14 years in jail. So you can elect to have a preliminary hearing. Or, for example, on a murder charge or a drug trafficking charge. So it's a very important right that they took away, by the way, for people now facing sexual assault or break and enters or other serious charges that can't have a preliminary hearing anymore. So what is a preliminary hearing? A preliminary hearing is an evidentiary hearing where the Crown calls certain witnesses of their case, and the Crown has to show that there's some evidence upon which a reasonable jury properly instructed could convict. That's the test. So in other words, if you pass that test, it goes on a trial. So it was very rare not to pass the test. It was a screening function, but it was very rare for defense counsel to successfully win outright a preliminary hearing just because it's such a low-level test. But the important thing, and this is why you should often have a preliminary hearing for a serious case, is it was a discovery tool for the defense to set up their strategies for trial. You could create inconsistency. For example, in a sexual assault matter, you had a video that you have of the complainant who gave a statement to police. At the preliminary hearing, you're trying to create inconsistencies, improbabilities with that video. The more you can create, the greater the credibility problems. And you can confront the victim at trial and say, look, you said this at one time, you said this another, you're not telling the truth here, etc. And you learned everything there was about the case. Now, on a sexual assault matter involving an adult, you're going in a little bit blind to the trial. True, you have full disclosure, but you don't have the benefit of that transcript under oath where you know exactly what she's going to say or he, and they're totally pinned down so you can develop your strategy better. So this is the new state of the law. We only have preliminary hearings now for very serious indictable offenses where you're facing a mandatory maximum of 14 years or more. And there's been a lot of criticism about losing this fundamental right. There's a lot of legal commentators who believe it's going to result in more miscarriages of justice. Certainly, I'm sure the vast majority of people are truthfully guilty in Canadian criminal law, but what about those innocent ones? And we are often able to create reasonable doubt by using the preliminary hearing as a tool. So that's all well, great, and dandy for everyone who's truly guilty, but what about the innocent? I'm wondering, and other commentators are wondering, if this is going to create more miscarriages of justice in Canada.